I'd like to welcome you to the third in our series of the McCarthy era in the scientific community. Before I introduce our speaker, I'll remind you of the next talk in this series by Dr. Manan next Monday. And then next week, we don't know exactly the times, there'll be the screenings of the Edward R. Murrow film, See It Now films, scheduled for sometime next week, and also Point of Order. We can't tell you exactly when they're going to be because we are somewhat at the mercy of when these films arrive in the mail or by U.S. mule. At this time, I'd like to introduce our speaker. It is our pleasure and our privilege to welcome Professor Norman Ramsey from Harvard University. Professor Ramsey is a professor of physics there, and not that it makes any difference to any of you, but he was also my thesis advisor when I was there. Professor Ramsey got his PhD at Columbia from Professor Robbie, and went from Columbia to the University of Illinois, and then from the University of Illinois to the radiation labs in 1940. And from 1940 to 1943 was here. From 43 to 45 was at Los Alamos. And from 45 to 47 was back at Columbia as on the staff. And then in 1947 came to Harvard, where he has been since. In 1953, basically the reason why we've invited him to the events, leading to the reason why we invited him to speak here today, took place when Joseph McCarthy came to Boston for the hearings involving Wendell Furry and Mr. Kamen from Harvard University. Professor Ramsey was involved with and counseled on the defense for Professor Furry, and he's going to talk today about those times. And as kind of a special treat, he has, and I hope it'll work out all right, but he has a tape of the hearings, and he's going to play part of the tape of the hearings, which you can hopefully pick up some of the mood and the tone of the kind of hearings and the manner in which Joseph McCarthy conducted himself. So at this time, I'd like to welcome Professor Ramsey.
Put this on there. My neck in the loop. Well, the subject of the McCarthy era and the scientific community is a big one, and particularly with the array of knowledgeable people that have already talked, it seemed to me the best way for me to proceed was to make the present talk an extremely personal one, just simply a recounting of my involvement as the time went on, and essentially in this course of it, it goes in and out with McCarthy, as you will see, and do it in that form, though I warn there are many other aspects clearly of the subject, therefore, that won't even come up in this. Now, in particular, then there's always the problem of where do you begin on such a discussion. I think in some respects, to give a little bit of background, I think the right place to begin is just about the end of World War II, for the simple reason that I think that did provide one of the key backgrounds, which I've always interpreted was one of the key sources of the success, while he had success of McCarthy. And this was the fact that at the end of World War II, in a certain sense, everything seemed to be going just remarkably well. You know, the war came out after it looked as if it was going to go the wrong way. It came out the right way. The United Nations were getting established. Clearly, this was going to give peace forever in the future. Relations with Russia was an ally. Everything was really going just right. And I think there was an extremely high optimism within the country. It's maybe hard to imagine at the present time, with present points of view. Nevertheless, there was extremely high optimism that if provided the U.S. government did the right things, everything would turn out just right. Well, now it's nice to have some optimism, but of course it has the inverse implication, namely if anything goes wrong anywhere in the world, it's clearly the fault of the U.S. government, and particularly the fault of probably some traitor within the U.S. government, and that's exactly what happened. Shortly after the end of World War II, things didn't go quite as much right as intended. The Russians seemed to be a little more intent upon holding on to Hungary and other of the countries in Eastern Europe. There were some problems in the Mideast that were lowering their head, and above all others, probably China, where it looked as if essentially the group that had been our allies during the war were suddenly shifting to the losing side instead of the winning side. And as a result, I think, of the optimism that occurred earlier, this led many people who wouldn't otherwise even have done this to essentially assume that since things are going wrong, that's obviously a traitor who's making them go wrong. So you look to see where they are. And this indeed led to, particularly within the State Department, people looking in various committees prior to McCarthy's period, looking into that and having various investigations of loyalty and things of that kind, because clearly from the point of view of many people, if things were not going right, somebody must be misbehaving. And it's really out of this kind of thing, I think, that the McCarthy era was started. But it was not by any means, McCarthy was not in on the beginning of it. In fact, as far as my involvement concerned, precedes his in that connection. Namely, there was a House Un-American Activities Committee, which actually goes back even earlier than this, but in that particular time was the Velde Committee, under the chairmanship of Velde, who was making investigations within universities in general, basically for former communists. And then there was the Jenner Committee in the Senate doing likewise. And these had a fairly good technique going. In fact, there's one technicality I think I should start on quite early, because I think it is the other key success of not only the McCarthy proceedings, but also of all the ones of the other committees, and in fact, in general, enters on the TV hearings. And this is a technicality of the Fifth Amendment and its application to hearings, TV and otherwise. And this technicality is a familiar thing ordinarily. I think most of you know the Fifth Amendment is part of the Constitution, which specifies that you are not obligated to testify against yourself in any court. And this is now, there's developed a procedure, goes back to English common law as to what this means. If it's going to be other than purely a nuisance, the requirement to not testify against yourself has to have an inverse side. In other words, you cannot, in a court, by any of the rules in British common law or in the United States, you cannot simply appear as a witness on your own behalf and say, I'm a great guy, I never did anything, I didn't shoot him, I didn't do anything wrong, and then step down without being subjected to cross-examination. This clearly would confuse things. And so the procedures on the rules of testifying against yourself is that indeed you do not have to be a witness against yourself, but if you do take the stand in your own defense, then you are automatically subject to cross-examination. In other words, you can't do one half without doing the other. Now the query is, how does this get applied when it goes to congressional committees that are, after all, not, it's not a trial in that case, but a man is indeed forced to testify, often against his will, because Congress can argue that they need this information for the sake of their function on legislation. But if they then do compel testimony, what is the analogous thing to saying that you're subject to cross-examination if you testify on your own behalf, because you are not you're not testifying in your own behalf. You'd probably prefer not to testify at all. Well, the rule that covers that, that's been worked up by the various courts, including the Supreme Court, over a number of years, is the so-called area rule, which is that indeed if testimony is compelled against you, if in the first place, if it is not testimony that itself will incriminate you, if it's on a subject, just they're investigating new legislation, you're compelled to answer. You have no choice in that. And on the other hand, if the question is one that could incriminate you, then you are entitled to refuse. But if you refuse, a so-called area rule applies. If you refuse to answer one question in a particular area, then you must refuse to answer all questions. That is, in particular, you cannot. This is analogous to the cross-examination thing. And then there's always a question of quite what the area was, and the general feeling at that time that one area was communism. This meant in particular, if you were a witness before such a committee and were asked who went with you to a meeting of the Communist Party in 1942, and you didn't want to get any of your friends in trouble by telling who was there and get them fired from their jobs, and you want to decline, you actually had a perfectly valid reason. If you yourself had been a member of the Communist Party, the Supreme Court had ruled that you were entitled to decline to answer that question on the grounds of the Fifth Amendment, because that answer might tend to incriminate you. It would imply that you were there. But this area rule then said that if you were going to refuse to answer that question, you had to refuse to answer all questions pertaining to communism. So the standard procedure of these committees, this was not invented by McCarthy, though he's the greatest exploiter of it, was indeed in a closed hearing to call the witnesses, and the first question asked of the witness in the closed hearing was, who went with you to a meeting of the Communist Workers Association in 1940? And if you declined to answer, then they would give you a vigorous warning what this area rule was. In fact, the most eloquent statement of it is one that I used once on a TV program, and which was given by McCarthy himself in a closed hearing, warning the witness that he couldn't do anything because the area rule said that he must refuse and answer all questions, having confirmed in the closed hearing in this nature that the man, because of his conscientiousness, many people who were involved, particularly in that way, would tend to be conscientious, even over-conscientious, did not want to get their friends into trouble when they felt they'd done nothing wrong. Once having determined the person was in that category, a public hearing would be arranged, and of course a totally different set of questions would be asked. Namely, the man would be asked not who went with you to a Communist Party meeting. Then anybody listening to TV could understand why people might not want to answer that question, but the question that would be asked in public would be, did you ever give secret information to communist spies? Well, the poor victim under that circumstance would have to decline to answer on the grounds that his answer might tend to incriminate him. In fact, he could be even compelled to have to say those words. And then McCarthy, who was the great master of handling this, would then summarize the proceedings to the audience, who were mostly doing dishes at the time or doing other work or sitting around a bar. He would summarize it and even slightly paraphrase it and said, well, what better evidence that it can be the great good being done by our committee? Here we found 6 traitors who've given secret information to communist spies, because what better evidence than there could be if the man, when asked this question, declines to answer on the grounds the answer would incriminate him? Well, this is a paraphrase. It might tend to incriminate what the man said and was compelled to say. But of course, if the chairman of the meeting, with all the American flag on each side of him, looking very official, says would incriminate him, it was a great TV show. People would say, here are 6 more spies found. They were found one after another, and this coupled with this sort of suspicion there must be something going wrong in the government because things weren't turning out the right way, made a great build-up for all of the committees. And I think it was the House on American Activities was certainly one of the originators of this, though the same procedure is used by other congressional committees in other directions. Well, as a result, in the period around the early 50s, the Velde Committee and Jenner Committee were thriving fairly vigorously, and sort of pure statistics. Any organization with a few thousand employees is going to have a couple of former members of the Communist Party. There was sort of a tenth of the minute fraction of the country in the Depression period. In the 40s had been members of the Communist Party, but nevertheless they were some. Say it's 0.1%. Well, that means there ought to be at least a few former members of the Communist Party in any organization. So it's sort of a nice, easy matter. If you wanted to pick on any particular organization, you could just hunt for the files. The FBI, as we now know, particularly has quite extensive files on arrangement things, and there seem to be ways for these committees to get hold of them. And you call on the people who are on there and make a pretty good show and make it fairly convincing what they're doing. Well, out of this, there was, under the Velde Committee, a hearing arranged here in Boston, to which Wendell Furry, who is a member of our department, was asked to be, not asked, told he would be called upon as a witness. The first I'd known that he had been had anything to do with the Communist Party, though he sort of was a little bit our left-wing representative, very nice, very conscientious fellow. And he came around to me one day just and sort of said, look, he had this problem, what should he do? Well, I had already been rather upset by the success of these committees and the rather cheap trick which enabled their success, namely this one I've recounted on this just misuse of the Fifth Amendment, and it's very hard to invent a way out of it. I'm almost the only way out. I was really quite convinced the better thing all the way around, since they had the names anyway, was really not to decline to give names. So actually Wendell and I had quite a long argument, the net effect of which was I think we both got quite convinced of the viability of the other man's side. In other words, I think Wendell really was quite convinced that I was dead right, that the whole thing these committees were thriving on was the fact that people were declining to name, that's what made it a good show. It would have just been utterly dead duck after a while. I mean, people don't like to watch TV just to hear people being sort of crucified and naming other people's names and resisting and not resisting successfully. But this other technique enabled him to get through it, and there wasn't much thing, and probably the best bet, I think he even was convinced rationally the best bet was probably to just go ahead and name the names. Say they had the names anyway, and do it. On the other hand, I also got completely convinced of him, of the difficulty from the point of view of the person who's in this bind. Namely, if you have been say a member of the Communist Party at some period in the past, if you're, as most of them were, extremely conscientious, maybe even excessively conscientious, you are certainly not going to want to get your friends and associates in trouble, first, and secondly, you know statistically that 4 out of 5 of them are going to refuse to answer the question, so they're going to be clobbered in the same fashion if you do name their names. And as the way things were going at that time, most institutions, including, alas, even most universities, were collapsing rather vigorously under the strain of that, and not, and very frequently actually firing the people on their staffs who were called, particularly if they were called to such committees, and did decline to answer questions. So that you had this dilemma what to do. And I certainly, although I still remain convinced that the best thing overall for the country and for himself and really even for his friends would be if he went ahead and did testify fully. I knew this also was sort of the university position on it. I also thoroughly learned to respect his position. In fact, I found myself in a rather good impedance match between Furry and the university at that point, for which several people in the university really felt very strongly. I mean, it was ridiculous for these people not to testify fully. I mean, and clearly were going to be trouble. And even at that time, Irwin Griswold, initially, who was dean of the Harvard Law School, wrote a rather eloquent argument as to why you should testify, that it was really a bad thing. But I had the happy position of, or unhappy one, I'm not sure which, of because of my position of being convinced on the one hand that that probably was the best thing to testify, and not being known at the other end, and also being convinced that I could understand exactly why a person wouldn't do it, and I could respect them thoroughly for not doing it, of carrying a fair amount of the argument on it. Well, in fact, in the case of the Furry case, that I did. Incidentally, one of the most useful people to have been convinced on this was Griswold, who later wrote some of the best articles on the Fifth Amendment, became sort of a specialist on the Fifth Amendment, and I always had an amusing feeling of how I educated the dean of the Harvard Law School about the Fifth Amendment. This was really quite true because it's intriguingly enough that even the lawyers didn't understand ordinarily the differences between the Fifth Amendment and the similarity of the same Fifth Amendment when used in hearings and when used in court. The same lawyers who would freely use the Fifth Amendment with their clients in court used it all the time. Sometimes they only used it because the man didn't look very good. Looking at the jury decided he didn't put a very good appearance, so they wouldn't call him as a witness. Same lawyer who would do that all the time would be eloquent about the horror of the universities having these so-called Fifth Amendment communists on their staff. Now, I had to remind him the inventor of the phrase of Fifth Amendment communist was actually Joseph McCarthy. There isn't anything in the Constitution about Fifth Amendment communists. But nevertheless, this was a phrase that sort of caught on, and the implication, if you used the Fifth Amendment, in that case, you were guilty. If you used it in a murder, something nice and clean like a murder trial, no difficulty whatsoever. Well, in any case, he had his hearings. One thing, incidentally, that emerged even at the time of these hearings that I got involved in, because he soon called on me to be essentially his lawyer within the university. I mean, I'm not a lawyer, but he decided, well, and the Harvard Corporation had discussions of the cases. He could bring a friend or a lawyer, and he decided I should be the friend. So for about a year, close to 2 years, I would say one of my major activities was as it were, a university lawyer. I'm not a lawyer, I'm a physicist, but nevertheless a specialist in one particular variety, not only of law, but university policy on this. And one of them then got involved in many aspects of it, many things that show up really very critically. For example, one of the problems that showed up very badly at that era was the problem of persuading lawyers to take cases when they involved these committees. Because of the bad publicity, this had never occurred to me would be a serious problem. But as soon as we knew that Furry's case was coming up. There was going to be the hearing. One of the immediate arguments then is that most of the argument frequently made, clearly these men were obvious out-and-out current operating functionaries of the Communist Party, because look at the lawyers they hired, who were lawyers who'd only represented the Communist Party in various cases. Well, I soon discovered why that's the case. Namely, no other lawyer was willing to take such cases. They would lose too much. So, in fact, we had, with the aid of the dean of the Harvard Law School, with Mark Howe in the Harvard Law School, the chairman of our department, Ken Bainbridge, Ed Purcell, and myself, we spent probably several weeks trying to find a lawyer who was both respectable and willing to take the case. Finally, actually, Mark Howe persuaded a young man, very recent graduate at that time of the Harvard Law School, Gerald Berlin, to take the case. But it just illustrates the difficulties you confronted with, because, say, one of the very good lawyers we approached at that time said, well, gee, he'd love to. He was noted as a liberal lawyer. As a matter of fact, he'd love to. He really felt his thing. But on the other hand, he was up for consideration for a judgeship. He got it, incidentally. And he really felt he couldn't afford to take a case such as that, because most of the lawyers who did, once you took one such case, then lots of people wrote you off as just a Communist Party lawyer, as it were. And so it was a bad case of circular reasoning, but nevertheless illustrates one of the problems. Well, coming back then, the Velde Committee hearings went on. They came off. These cases never come off very well, and it was indeed clear that Furry, and we learned something about it, had indeed been a member of the Communist Party for a rather surprisingly long time. He also had dropped out. He also had clearly done nothing wrong. He made one major error in his first meeting. As before, I was employed, as it were, as his lawyer with the university. The first meeting he had with the Harvard Corporation, they asked him how they said they would sort of stick by him, but of course they didn't want to get their necks out if he'd done a lot of tremendous wrong things, at which point Wendell suffers from the case of being overly conscientious and truthful. He said, well, there was really, in the whole 4 or 5 or whatever it was years he was a member of the Communist Party, he'd only once done anything that really bothered him later is the wrong thing, at which point he blurted it out, at which point the poor corporation had this stuck as to what to do about it. And this was actually that he had, one time, I guess, a government investigator had asked him about a person being hired for a job. Did you know if he was ever a member of the Communist Party? And actually, Wendell Furry knew he was, but he didn't want to get him into trouble. He also knew he's a good man, so he said, I don't know. He didn't say he wasn't. He said, I don't know. In actuality, he did know. And this was no end of worry, actually, the Harvard Corporation, who would sort of ponder it and say, you know, the motto of Harvard is Veritas, and what do you do? And in fact, one of the roughest meetings I think I've ever gone to was on the Velde Committee after that hearing. And actually, Harvard had the tough problem right at the time all of this was happening. Conant had just resigned from Harvard to be ambassador to Berlin, or High Commissioner, I guess as it was at that time, to Germany. And the Harvard Corporation, which are 5 people, I got to respect quite highly, as a matter of fact, who are part-time, really run the place in part, and they were at that time really running the place in that there was no president of the university, and they were hunting for a president, and at the same time they suddenly were stuck with all of the McCarthy issues and having to make the decisions themselves. Paul Buck was the provost of the university, did a splendid job with them, particularly convinced them they should go slowly and really look into each case before they moved. Well, after I met with them quite a few times, quite long lengths, arguing the case that really there was nothing that had emerged in this hearing that should mean that Furry should be dropped from the universities. Most universities were firing people at roughly that time for refusal to answer the questions. He had indeed refused to answer. And they finally wrote up a decision. I was invited to at a meeting of them, which decision was almost identical with the final decision, except for one thing. Namely, it's the decision in which they, Charles Coolidge did the writing, did a very beautiful job on it, that really university should not take the refusal to answer, and took our arguments really quite seriously, and that because of refusal to answer questions, this should not be grounds for dismissal. But then they said, but there is this other case at that time, namely this time he told their point of view, an untruth to a government official. This cannot be overlooked in a university such as Harvard, so we'll have to let him go for that reason. So that meant that the rest of the issue, we concentrated all out in that here. I mean, I forgot about all the other, there were words that should have been changed, but no worry about that. And we made, I think, a fairly vigorous point that, I mean, after all, he had brought this up himself. Almost anyone, if he brings up, what's the worst thing that you've done, I think you could fire any member of any university if he, you know, really honestly says, what's the worst thing you've done in the last 7 years? You know, I'd hate to get it. In fact, I said, I was making that point to the Harvard Corporation. I said, look, if you would probably have to fire almost everybody. And for example, if you ask me what's the worst I've done, I said, point immediately, they knowing the problem, they said, don't keep quiet. They said, don't give us another case. So they clearly knew that it was a problem doing it. Well, we just squeaked through it, as a matter of fact. It would have been sort of a real disaster had they done it. I could see why they would have done it on. That was something they invented, and they invented actually on their own. I wasn't clever enough to propose this to them. I think Charlie Coolidge, I understand, is most responsible for this. A very interesting idea which has not been taken up by other universities the way it should. And it's the reason I really go into this aspect at all, which was a board of trustees or corporation, whatever it may be, does have a problem when somebody's under attack. And always the case that's under attack is never the perfect case. I mean, Wendell's a great guy, but he always make the wrong statement to the press at the wrong time. He'd even make a crack about general education at the wrong time when that was the popular thing. You know, it just was, his tact was not always high. His honesty was extremely high. Is the point we made at that time. Look, his honesty is, he's the most honest member of the department, whatever you may think on other things. But in that case, it's very hard. I mean, the newspapers, of course, are featuring this all the time. The university's under pressure, and they sort of say, I mean, but gee, if honesty isn't the policy of the university, are we condoning dishonesty by not firing? But they eventually made the following great invention, which should be noted by more other universities, and I've never heard of it being done. Namely, when they kept exactly the same document that had so appalled us at first, all the same reasons, except at the end, having concluded again on the basis of this statement, an incorrect statement to a government official about whether he knew whether a person had been a former member, they noted the following fact, that although they did feel that that was indeed grave misconduct, and the grounds for being fired from Harvard are either grave misconduct or gross neglect of duty, that although telling known incorrect information to a government official is grave misconduct, they also noted that the Harvard statutes say that you can only fire a person for grave misconduct, not that you must fire a person for grave misconduct. So they actually ended up with the finding that on that particular issue it was grave misconduct, was justifiable of firing him. On the other hand, they weren't obliged to fire him in view of the testimony of his colleagues as to his honesty and assurances that this was not characteristic, etc. They'd retain him. Well, so that one came with just a squeak of it being a major disaster. That one came out fairly well. I think that, in fact, as I say, it's a procedure I wish that other organizations would adopt more frequently, because it is a real opportunity to what can something like a board of trustees do when they have a very embarrassing problem. They're under pressure. And this is one alternate that they should adopt more frequently, namely of being able to say, yes, this is the reason I could fire the man, but I won't, as opposed to saying I must simply because the act was wrong. Well, coming back now, yes?
The board of trustees or whatever doesn't have to interview the man.
Oh, well, there are a lot of things they can do earlier. You're quite correct. They don't have to interview the man, but they were learning, and I think that's one of the better procedures, is not even to get that far.
Maybe that's what they learned.
That's, I think, one of the learning. You certainly don't ask them the question, what's the worst thing you've done as a member of the Communist Party? Don't do that under any circumstance. There are a number of things they learned in the process. So much, at this point, it looked as if the problem was sort of over. And as you may note, I haven't even gotten to McCarthy yet, but we will. And things seem to be settled down. And then two things happened. One was the corporation did decide who should be president of the university. And the man they chose, Mr. Pusey, was from Wisconsin, which was McCarthy's home territory, and was one of the very few people in the state of Wisconsin who had been quite vigorously outspoken against McCarthy during his last Senate election campaign. And McCarthy and I'll give my reasons for knowing this. It's not just hearsay that I'm speaking of now. McCarthy has had a simple procedure, what you do when you're mad at somebody. Well, you take advantage of the fact that if he's in a large organization, there are some communists there. You can find out the lists of who they are. They'd already testified before another committee. And you call them up to testify, and then you really crucify the institution and the individual all at the same time. And he was much more expert at doing this than Velde. I mean, he was a real genius from the point of view of getting maximum publicity per hearing, and the real genius in even his phrasing of words. He could make a statement. He frequently made statements which were utterly incorrect, but he could even make a statement that was technically correct, but led to exactly the opposite impression. Well, he did this with great, and would have sort of daily press releases, so that he, in any case, was therefore very mad at Harvard for having elected Pusey, the man who'd opposed him in his home state, as president, and he was going to go out and get him. And his way of doing it was he could look up the hearings of the Velde Committee, and here was the victim, again, Mr. Furry, also Mr. Kamen, both of whom had appeared previously, so it was no new discovery. But then he really started running the hearings as the real master. And I say from the point of view of publicity, he was absolutely a genius. For a period of about 4 months or more, I would say the Boston papers, particularly the Boston Post at that time, usually you had the main headline, sort of a 2-inch high headline across the front, was something or other pertaining to these hearings. I mean, there was a closed hearing, then an open hearing. McCarthy would let out juicy bits of information on the misinterpretations, usually, of what happened in the closed hearing, which he would then repeat, get in the newspapers, write letters to the president. Well, typically he had a closed hearing with Furry, determined indeed that Furry was at that period also going to use the Fifth Amendment. And then he had a absolutely terrific campaign of letting little bits out. He would send telegrams to the president of Harvard saying, why haven't you fired, and release a copy, of course, to the press. Why haven't you fired Wendell Furry from your staff, who is misleading the American youth, etc., in this direction? And Pusey, somebody in Pusey's office replied, I mean, we have no evidence one way or another. I mean, it's a closed hearing. To which then he said, but look, if that's a typical one of his narrative, if I have, says he, a witness in my closed hearings who says, when asked if he's given secret information to communist spies, said he refuses to answer on the grounds his answer would incriminate him. That's the clearest possible evidence that he is a collaborator with communist spies. And well, it turned out that didn't happen. He actually that particular hearing, Furry wasn't, because that later was released, that Furry wasn't even asked that question, and he didn't give that answer. If he'd given the answer, it would have been might tend to and not would incriminate him. So I mean, it was tough, but nevertheless, it was great for headlines in papers, as you might well imagine. And he this continued. He was on a Meet the Press program at roughly this period, in which he vigorously attacked the university for both its president and for its communist staff. In that sense, I think one of his statements in the press interview was, it's inconceivable that any true American parent would send his child to a university that does nothing other than indoctrinate their students in the communist conspiracy. Well, this was sufficiently vigorous, in fact, on Meet the Press, that Spivak, who runs the show, was a little worried he should get the opposite side. Anyway, what he tries to do is get opposite sides. That's what the show thrives on. And so Spivak's first thought was to get Wendell Furry on the program, to give the opposite side. Well, so at first I knew of this particular problem. Wendell came around. By then, he'd made enough bloopers in his press releases that we'd made a friendly agreement between the two. He would check with me before he made any press release. So he came and said, look, he'd really like to be on and answer this, and what did I think? And I said, that'd be sheer murder. I mean, first place, it's very difficult to be on that kind of a program. Second place, Furry's not at his best in that kind of thing. And defending yourself is just an impossible position. It's hard enough to defend somebody up, but if you've got 3 sharp reporters asking you nasty questions, all you can count on is looking much worse at the end, and the likelihood of his doing something that would get himself in much more serious trouble is much greater. And also even both with courts, both with the committee, revealing information of what kind of questions might be more relevant to ask, and also even with the corporation in the sense of making even more embarrassing bloopers with them. So I convinced him, and indeed I think genuinely convinced him, he certainly should not do. So he told that to Spivak, who then tried to get Pusey to appear. And Pusey, I think, quite intelligently declined to appear on the grounds he did not think that the nature of McCarthy's attacks were such that it should be dignified by the president of the university responding. Secondly, Pusey had just become president of the university. He wasn't all that familiar with the details. There's a very easy chance that he could be trapped on some detail he didn't know, which would look up rather badly. And thirdly, even almost more seriously, there was a real danger that as the president of the university, he might find himself in the awkward position of declaring policy, i.e. be asked some questions such as, well, it's true, you have some people on your staff that were former members of the Communist Party, and you're not firing them. What would you do if you had a current member of the Communist Party? Would you or would you not fire him? Well, in the heat of the discussion, without much thought, talking about others, he might say, yes, we would. And then suddenly you're stuck with a policy, and it's very hard then to change course. So I think quite wisely he didn't want to do it, so he declined. Well, poor Spivak was getting nervous about his program. He tried to get Furry to appear, tried again to get Furry to appear, and Furry told him at that time not only was he convinced he should not appear, but he was also, he'd also promised me that he wouldn't do so unless I gave him permission. So Spivak called me and asked me if I would, and then asked me if I wouldn't release Furry from that, and I argued with fair eloquence. Well, the net upshot of it was I suddenly found myself inheriting the task. After a little check with Pusey, there's no objection on the part of the university. I ended up with about 3 days' warning, having agreed to be on the Meet the Press program following McCarthy. This was the first, incidentally, anti-McCarthy TV program. It precedes the Murrow program that you're going to have next time. It was actually, in this case, a regular Meet the Press program with 3 quite unfriendly reporters, one slightly friendly reporter, asking hard questions. And the program, as soon as I learned I was going to be on it, I decided that was really extremely important to do well. I dropped everything else for the remaining 3 days, spent my time in the library reading the New York Times, all the past things of the hearing. So I really was an expert about much more of an expert than McCarthy was, about what his committee had been doing as of that particular time. Incidentally, it was what was going on at that time were his hearings pertaining to Harvard University and the hearings at Fort Monmouth, which were eventually the things that did him in that these were the Army. This preceded the Army McCarthy hearings, but they were actually his hearings at Fort Monmouth that got rise that. But in any case, these were going on. One thing I was quite aware of, since I'd done some research with relating close to some of the things done at Fort Monmouth, what a tremendous amount of damage his hearings were doing at Fort Monmouth. The whole place was just sort of wiped out for period of a year or so with the effect of the hearings. The people who were being fired there, they were failing, they couldn't keep them. It was a real disaster on that. So I became a fair expert on that in the remaining few days. Well, the Meet the Press came on, and I think on the whole it went off fairly well. One of the things I had resolved, I brought one piece of written material with me and I was going to read no matter what, and I got an excellent chance to read it, which was McCarthy himself had given a particularly eloquent statement of this area rule that I began with. If I'd been on my toes, I would have brought a copy of it here, but I don't have it. He had given a particularly eloquent statement why you must refuse to answer all questions if you answer anyone was really right relevant to the point. And I got asked the right kind of a question. I could read that statement, which I think could do a lot to inform people as to really what was behind the hearings and the misleading way in which it was done. On the whole, I think the hearings, in general feeling, went off fairly well. One useful thing I've been told, I don't know whether it's true, that it's partly this hearing that this program that's partly led Murrow interested in making his program, which is a much more, obviously much more finished job. And if so, I'm always delighted that done it, since it was a great, he really did a superb job in getting rid of it. But nevertheless, this hearing came off. It got over as they were run at that time. The program ran from 6 to 6:30, done live then in Washington. And I'd already agreed at the time of the hearing that I would eat dinner with Spivak and his wife wherever they wanted to eat dinner, and then take the night train back. And it's the days of train travel, actually, it reminds me. And well, the program got over at 6:30. The reporters and I were continuing to argue. By the end of the program, we'd forgotten about the fact that whether we were on the air or weren't on the air, we were really going to. We were joined as vigorously after we were off the air as before. And while we were still in the midst of these arguments, about 6:32, after the program over a couple of minutes, PA system comes on there and says, Mr. Spivak, Senator McCarthy on the wire. And I said to myself, I expected retribution to set in, but not quite so rapidly. Indeed, it was McCarthy on the wire, and according to Spivak, he started in by bawling out Spivak for having gotten me on the program, since it had turned off not the way he had looked. In fact, it emerged in this conversation that he and a group of his close and intimate friends had had a small party, dinner party, to watch the slaughter of the Harvard professor on TV. And since it hadn't come off, they were a little bit disconcerted, and they wanted to get life back in the party. And the net effect was that Spivak exercised this option he already had for me to go wherever I go with him for dinner, to accept an invitation to go to dinner with Senator McCarthy and his choice friends. I had a little bit of a worry. I felt I could at this stage, back out. That wasn't quite what I had in mind when giving the option, but I also thought, there might conceivably be. This was between the Furry's closed hearing had occurred, but his open hearing had not. Maybe I didn't think that was likely, but maybe I could convince McCarthy that he ought to just forget about it. So it was probably wise to do, and I was going to guard myself with care to make sure I didn't drop any bricks that would give more ammunition to McCarthy. If I did it with care, it would be worthwhile. So I went out. Well, now it turns out that McCarthy, I learned a lot about McCarthy from said dinner. Well, first place is to the guest. The guest list was at the home of the then owner of the Washington. What is it? It's now the Washington Post. It's with another Post.
Star?
What?
The Star?
Washington. No, Star's the evening one, but the morning one.
Washington Telegram? Was it the Star
There's
Telegram?
only the Post is the only
No,
one.
no, but the Post now has a double name. Well, because they bought it up. They went out of business, the other one. Well,
News.
But
Well, News, I think the Star.
News bought, well, I'll think of it in a moment. In any case, Basie Dahl was her name. She's the daughter of Colonel McCormick of the Chicago Tribune, and a good illustration of the kind of newspaper that she was. Wait, was it the Washington Times Herald or? Well, I'll forget it. A good illustration of the kind of a newspaper she ran there was actually that around that time their newspaper got into financial difficulties. In fact, it got into extreme ones, such that the Washington Post of an opposite ilk bought it up. But she got into some financial difficulties with the paper, and she tried to borrow some money from her father or uncle, whichever it was, Colonel McCormick, who runs the Chicago Tribune, and he refused to lend her money on the grounds that her newspaper was too reactionary. So you sort of shows the kind of guest. The other guest was a man who most worried Irwin Griswold when I told him that he was there. He was much more concerned about the company I had. It was a Dean Mannion, who was former dean of the Notre Dame Law School, which was apparently, amongst the lawyers, the most notable reactionary lawyer. In fact, it was actually the first man, a little thereafter, the first man fired by Eisenhower because he had a job as, I don't know, coordinator of committees, and he spent all of his time making speeches against the administration. In fact, everybody at the party except myself had utter disaster occur to them later. I think no one survived more than about a year or so. But in any case, this was hitting them at their high time. It was a great dinner. I mean, as I described to some of my friends after, we had a nice big thick steak about that big. The only thing different from if we have a party for about 10 people, maybe have a nice thick steak about so big, we don't give one to each person. But there we had one to each person like that. So it was a fine dinner. And McCarthy has this double manner. I can see why. I could see from this how he could get his election, because he could be, well, I put it in several ways, much more amoral than immoral. mean, he could really think he was being very honest, and he could be the good old Joe on the one hand and then the absolutely mean person on the other. And in this one, he started off being, well, really the whole evening, he was the good old Joe mood. And in typical being, as we walked in the door at the Bézidal's home, he leapt up, ran into it, and greeted me, shook my hand, said he, "That was a great performance you put on. I don't know how much Harvard pays you as a professor of physics, but I'll make it double the amount if you'll be my director of public relations." Now, my friends pointed out that this would have been sort of a rough job if I had taken it at that time, since this was just about his peak, and it drops in. In fact, if I wanted, I'm always a believer in the virtue of lying in statistics. I can make a nice plot of McCarthy's stature as a function of time, and then I appear on a TV program, and it immediately goes down. I'm not claiming that this is the cause, although I hope it helped a little bit. Well, throughout the evening, no one else had a chance to get even a word in edgewise in the conversation, or very little. And for about 4 or 5 hours, I guess, we argued with great vigor, and I learned a lot about him in the process. As I say, he was in that whole evening, being in the good old Joe mood. He was also drinking fairly heavily, which helped him to be in the good old Joe mood. More than that, he was way ahead of me on that. I wouldn't hope to match that. But it also became very quickly apparent that as far as doing any good with arguing, namely convincing him of anything, was really out of the question, even in pertaining to the details of the hearings, for the simple reason. It was almost like trying to scoop exactly 1 cubic foot of water out of a swimming pool. You scoop it up, more water runs in, and this was the characteristic. He had the advantage of having, when he wanted to, of having a very poor memory, and I think genuinely poor. But I mean, he could sort of turn it off and on a little bit. And in particular, one of the things which I had studied with fair vigor, well, one of the statements which he made about half a dozen times during the course of the evening, particularly when backed into a hole. I was basically pointing out to him the damage that his committee was doing, then he would try to respond, but the good that it was doing. And one of the good that his committee was doing, what he would say, but look, there are 6 communist spies at the federal laboratories in New Jersey that we have had before our committee. Well, I had studied my paper with fair care, and in fact, there were several things wrong with that statement. First, he didn't have any communist spies there. He had indeed 6 presumed or possibly former members of the Communist Party who declined to answer questions on the grounds of the Fifth Amendment, and probably because they didn't want to get their friends into trouble. And secondly, these federal laboratories that he was talking were not part of the federal government. That was part of the federal telephone. It was a federal telephone laboratory, which for present day is part of ITT, not of more recent fame and other connection, not part of the federal government. But again, so I would point this out to him. He'd say, "Oh yes, that's right, sure," agreeing fully to my surprise. And then 5 minutes later, when backed into another hole, he would say, "But look at all the good our committee is doing. We've got these 6 communist spies at the federal laboratory." I said, "But that's where we were 5 minutes ago." "That's right," says he, and go merrily on. Also, he just did one thing was also apparent at that time. He just shortly before that married his staff secretary, actually, of his committee. And she actually, the combination of the two was much more worrisome than either. In a certain sense, McCarthy was absolutely superb at sort of shooting from the hip. He could the neat phrases dropped from his lips with ease. They were possibly wrong statements, but nevertheless, they sounded great. But it was also clear that he alone, I think, wasn't much of a threat, in the sense that he had no deep planning. I mean, he would be easily backed into a hole. Usually when backed into a hole, frequently his wife was actually the one who would finally pitch in with very dull comments, but nevertheless pitch in and sort of make a comment to try to get it back what was, from his point of view, on the right track. Well, this went up until I was, I think I even missed, I'm not even sure I didn't miss my train getting back. But we'd finally terminated. It was quite clear that probably I wasn't going to succeed in stopping the public hearings, and it did not. These hearings occurred. These are the hearings for which I have a tape recording for a portion of it. I just will play the last little bit to save time. And again, though, showing the relations of that, he Wendell Furry's wife, asked me to go with her to the hearings. I felt at the time, I also, since there was probably going to be a court trial emerging from it, I would like to have a tape recording, so I asked a then graduate student of mine, who incidentally is now the director of research for IRTA, John Team, to make a tape recording from his TV, which I'd planned to do myself originally, but then I was going with them to the hearing, or going with Betty to the hearing, which I did, and he did make the recording, which recording did eventually appear in the court trial, as a matter of fact. And at the hearing, I sat next to him. There he was being his most brutal self. I mean, he really, as you'll see, and I'll play a little the end, sort of his summary, sort of summarizes. It's either for Furry or for Kamen, I'm not sure which, saying sort of it's inconceivable that Harvard University would, a once great university like Harvard would keep such creatures on its staff, not even dignifying them as persons. So having done that in this very brutal form, I was going out with Betty Furry at the end of the hearing. He'd also told Furry, well, he'd have to appear in a closed hearing. Now, actually, at the hearing, both Kamen and Furry, on their own hook, and I don't think even either knew the other was doing it, though they may have talked about it a little bit, had both decided that the Fifth Amendment procedure was just causing so much trouble to so many people, and the universities were treating them really quite well out of it. They were getting all the other people in trouble, that they would decided two things. One, that they would abandon the use of the Fifth Amendment, but two, they would not name names of the people. This put them in very major jeopardy of contempt of Congress, but that they would say on the grounds of the First Amendment, not the Fifth Amendment, and on the grounds of the relevance of the investigation, which was the government investigating committee, and that Harvard was not part of the government, that on that basis they would try to do it, even though it meant that they gave up the sure protection under this. Well, they both adopted this procedure, which sort of threw a monkey wrench actually into the machinery as far as the McCarthy hearing was concerned. In fact, it almost gave a little the opposite side of it, and it was sufficiently upsetting to him that he got invited back to another closed hearing. And, well, in any case, at noontime, having done this, having treated Furry, as we knew to be a good friend of mine, extremely brutally, in going through the corridor, just so happens Betty Furry and I are going one direction through the corridor when Senator McCarthy and his wife are going the opposite direction. He looks up, sees me. I was, looking the other direction, rather just fuming, more or less. And he sees me and he immediately reverts to the good old Joe mood and said, "Gee, I'm glad to see you're here. We're really doing great things." And in fact, said he, if you really want to see what good our committee is doing, we've got closed hearings this afternoon with a bunch of GE employees, and you really see how it works. Won't you come to the closed hearings? Well, there again, I had to make one of these quick decisions, what I should do. I wasn't any eagerness to go to it. And in fact, that evening I was ill, just going through the whole rigmarole. I've never had a nervous strain that's been as bad. But I also knew that Furry was invited back to a closed hearing. And the previous closed hearing, McCarthy had released a lot of incorrect information. It would probably be a good idea if I were there and could tell Harvard just what had happened. So I, repugnant though it was, in the presence of Betty Furry, I accepted the invitation to attend the closed hearing, which I did, which was far, far more appalling than the open hearing. I think I'm probably one of the few unfriendly people, other than the witness himself, who's ever attended one of these closed hearings. It was the nearest I've ever seen to sort of almost sort of a Nazi mass execution kind of thing. First place, General Electric Company. These were hearings of General Electric employees at Lynn. General Electric Company had announced the day before that any GE employee who used the Fifth Amendment before a government committee would automatically be fired without exception. So you knew anybody who used the Fifth Amendment before the committee, even for whatever reason, was out of a job. And he must have had about a dozen people called, of which about 10 or 11, indeed did use the Fifth Amendment. So you knew perfectly well the next day it was going to be, they would be done in. In fact, I listened in and made a recording myself of the hearings the next day on it. But it was really very, just terribly upsetting. I mean, one of the things, there was a Massachusetts Un-American Activities Committee in existence at that time. So I was seated next to the chairman, a woman who was the chairman of that, whom I really must admit I rarely disliked anyone more other than McCarthy. And a typical kind of procedure was and typical, I think, of McCarthy. One of the victims who had already just made it clear he was using the Fifth Amendment, was therefore fired from his job, was going to be fired from his job, was told to come back to the next day for the hearings, and he looked a little fumbling around, and Senator McCarthy said, well, he wanted to check on train schedule whether he could be in by 9, and McCarthy said, oh, well, it's all right to come in at 9:30 for it, and this woman sitting next to me as chairman of the Massachusetts Committee said, that's what I like about Senator McCarthy, he's so considerate. And I considered this about as unconsiderate a thing as I could be, after losing the man his job. And they say that it was just sort of a mass execution. The other first two, the Cayman and the Furry, when you at least had the feeling their own organizations were standing behind him, but these other people were just well, let's say we're losing their job. In fact, I've always thought it would be an interesting sociological research project for somebody to take those 12 people, 11 people, I guess it was, who actually used the Fifth Amendment, see just what happened to them. I've never known since. I mean, they obviously were fired. Did they get other jobs? What happened? I don't know. Certainly, but it's a real tragedy from my point of view. And I say, I went home that evening after the closed hearing, and the first time I think I've ever just, I was running a fever. As far as my wife could tell, just from nervous exhaustion. You just felt that it's just like sitting in on an execution, which indeed it was, an execution of loss of job. Well, the hearings went on. The public hearings for the GE people were the next day. And I say I have a recording of one of those just to diminish the time. And then the remaining, to sort of finish the story as concerns Cayman and Furry, indeed they did opt to tell about themselves, but not about others. They were cited for contempt of Congress. The first case up was the Cayman case, and actually the same tape recording you'll play here, although I won't play the Cayman portion, was used in the trial for really two reasons. The technical reason was that since the person using the Fifth Amendment is supposed to be exercising judgment as to whether he can or needn't do it, he's supposed to be given an explanation of what the purpose of the hearing was, and McCarthy always used to begin the hearings with what I used to define as his commercial, namely a statement of the great things that we're doing, how he was uncovering the communist conspiracy, etc. He'd give that first, and that was sort of the justification. Then the person knew what he was after. Well, when the trial came up, Cayman's lawyer and Cayman both stated that they had not been present when this was done, which gave them grounds to argue, and they weren't therefore properly warned. On the other hand, McCarthy said that they were, and in fact, as you listened to if you read the transcript of the trial, of the hearing, it seemed to justify what McCarthy said, in that there was a statement. I mean, the first witness will be Mr. Cayman, then Mr. Cayman takes the stand, sworn, etc. Well, I listened back when I heard there was this controversy. I listened back to the tapes, and although the words were correct in the trial, it comes out quite differently on the tapes. Namely, they say the first witness, there's this spiel, a McCarthy commercial, then the spiel, the first witness will be Mr. Cayman, and then a long silence, and then a hoarse whisper comes through on the tape, not in the record. I think he's in the other room, and then a clonk, clonk, clonk of feet as people go out, clonk, clonk, fire siren down the street, clonk, clonk, people come back, a microphone gets knocked over, and about 2 minutes later, he's taking the stand. Quite clearly wasn't in. Now, this wasn't probably expected to be a very major issue in the case, so that would be helpful, but the real reason the lawyer was very eager to do it, this gave an excuse for introducing the tape. And what he realized was that, particularly after having listened to the tape himself, is that you get a completely different view when you hear it and actually sort of hear the tone of voice than you do otherwise. And he wanted the judge, who was a case tried before a judge, Bailey Aldrich, to actually hear it, to see just what it was intended. And actually the judge did extremely well. He did indeed rule in the Cayman case that the committee that McCarthy was on was the Committee on Government Operations at Harvard University was not a government operation, and therefore the whole questioning was irrelevant and inappropriate, and therefore Cayman was acquitted, which automatically meant that Furry was acquitted, and his case never actually came to trial. And well, shortly after that time, McCarthy was beginning to be on the down skids at that point. The Army McCarthy hearings came up. His drinking problems got to be more severe, although we were going pretty good guns that evening I had dinner with him. And that particular era came to the end. Well, now in conclusion, what I do have is just, in fact, I have a tape recording both of the Kamen and the Furry hearing, and one of the GE employees. But I listened to it a little last night, and to save time on it, I think the best thing to do is to pick it up pretty close to the end of the Furry hearing, because it's a long procedure. You know, there's always misunderstandings, argument. What about man number 5? Who went with you where? And save that. I'm just picking it up at what I thought was a reasonably typical place to make it a reasonably shorter thing to fit in time. So if this is still working, let us see if we can play it. So this is starting. This is sort of the last, I would say, 20% of the Furry hearing, and all of the hearing of one of the GE employees by the name of Gregory.
This is the.
Sorry?
This is the opening.
This is the open hearing.
Was this one on television?
This was on television, in fact, and John Team, then my graduate student, made the tape from the television. It turned out the television station didn't keep their tapes. They have too big a record of tapes. So this is, as far as I know, the only record. At least it's the only one the lawyers could find for the trial. Actually, this is a copy of the tape, the actual one they used. I'd had the wit to keep in a safe so that nobody could. You have to account for the one thing. Shows a remarked difference, I might add, between two different procedures. It turned out in the same courtroom, Bailey Aldrich had the trial for contempt of Congress of Kamen. It was in the same courtroom in which McCarthy had the hearing. And never have I seen two opposite procedures of fairness and justice. In the case of the McCarthy hearing, I mean, everything was stacked against the witness. The summary given was a totally dishonest summary, making it look much worse and be misleading. He was not allowed to, just everything was negative. That, in contrast, the Aldrich trial on contempt was done with meticulous care, and good illustration was approximately 1 day of the trial was devoted to getting this tape in evidence. I mean, I had to testify exactly what the history had been of the tape. I had to get a deposition from John Team, who had taken the tape, as to what he had done with it before he handed it to me. The manager of WBZ, from which it was taped, had to be on the witness stand the whole time it was being played to testify to the best of his knowledge that this was what is consistent with what went out. So it's clearly it was a really intriguing contrast to sit in the same room and see essentially a summary execution on the one hand, as it was with the GE employees, and then a year or so later see justice being handled with really great care. I was very impressed by that trial. Well, here it is. So this is picking up close to the end. I'm not censoring anything, and in fact, it's just to save time is the only reason I started.
Last time you were before us, you refused to tell us whether or not you had attempted to indoctrinate your students in the communist philosophy. Since that time, there has been a demand by a number of people for your dismissal. But aside from one of the grounds, I assume you changed your story on that today, too.
Well, sir, I didn't tell any story last time, so I'm not changing any story. At present, I am happy, since I am not obliged to refuse to answer questions in order to protect my privilege, to answer that I certainly have never attempted to indoctrinate any students with communist philosophy.
Then, when you told, when you told us that you thought that you answered that question, the answer might tend to incriminate you, at that time, were you aware of the fact that you never had attempted to indoctrinate any students?
I was aware of it, and I was also aware of the doctrine of areas under the privilege, which you had expounded very ably yourself, sir. And this certainly would have come under that area and would have been a waiver of my privilege. It certainly is a matter of law that a witness has to refuse to answer all questions that come within such an area. That was, of course, my constitutional ground for invoking the privilege, and in fact for having to invoke it. I'm very glad that on that question, that I don't have to invoke it today.
Do you know of anyone connected with Harvard who is or was a member of the Communist Party?
Sir, I'm not sorting people for the committee.
Answer the question.
Well, I would like to make this statement, and that is that I have never at any time known anyone who held a permanent position in the Harvard faculty, with the exception of myself, or who has since come to hold, or who now holds a permanent position in the Harvard faculty, to be a member of the Communist Party. Apart from that, I'll refuse to answer the question.
Well, your definition of permanent may be different from mine, I don't know.
My definition is the rank of associate professor or professor, which carries...
All right, well, let's go a bit below that then. The question is, do you know anyone in any way connected with Harvard who is or was a member of the Communist Party?
Sir, there are all sorts of difficulties with this business of naming and sorting names, and I am very glad that I'm having nothing to do with it. One of them is that indications, opinions, impressions, and differences of people's statements come into it, and that makes it not only one of the most distasteful notions I can think of to engage in, but also an extremely dangerous one. And I am not going to answer that question.
You're ordered to answer the question.
I refuse, sir.
You have given us now the names of, you've told us that you knew 6 communists, one either who was or is working in electromagnetic wave research, the others working in the other departments, the radar laboratories, one on the atomic project. Can you tell us, you may have answered this before, I'm not sure, can you tell us where you would find this communist today, the one who is working on the electromagnetic wave research project? Is he still in that work?
Certainly not for the government, sir, but I've refused to indicate the present employment.
Is he in that type of work?
In scientific work, sir, and I have no doubt sometimes having something to do with an electromagnetic wave. But I refuse to indicate the kind of employment.
You were ordered to, I assume you still refuse.
I still refuse.
I believe you refused to tell us what university he's at.
I refused to even say whether it was a university or something else.
Well, I understood you to say he was
But I
working.
said it had no connection with government work.
Is he at a university?
No.
And you know where he's working, though?
Yes.
Mm-hmm.
Roughly.
Is it for a company that's doing any government work?
No.
You're sure of that?
Yes.
Mr. Furry, you may step down. Mr. Counsel, may I say, as a courtesy to counsel, we always inform counsel when we intend to submit cases to the Senate for contempt. Obviously, this case will be submitted into the grand jury. First, may I ask if any additional questions? I'm sorry, I meant to ask the members of your commission, if you've got any questions at any time to ask, just submit them to me. I'll be glad to ask them. I think we've covered the field pretty well. Okay.
Am I dismissed from the subpoena, sir?
No, you're not dismissed from the subpoena. You'd consider yourself under subpoena. May I say that you're dismissed for today. You'll be notified when you're wanted.
This subpoena's been running for some 3 months now, or 2 months more.
Isn't that terrible? This, in the opinion of the chair, is one of the most aggravated cases of contempt that we had before us. I think one of the most aggravated cases. Here you have a man teaching at one of our large universities. He knows that there were 6 communists handling secret government work, radar work, atomic work. He refuses to give either this committee or the FBI or anyone else the information which he has. To me, it's inconceivable that a university which has had the reputation of being a great university would keep this type of a creature on teaching our children. A strange idea of Americanism. Because of men like this who have refused to give the government the information which they have in their own minds about communists who've been working on our secret work. Many young men have died in the past, and if we lose a war in the future, it will be the result of the lack of loyalty, complete unmorality of these individuals who continue to protect the conspiracy. You may step down. The committee will adjourn until 2 o'clock this afternoon, at which time we'll have an executive session, and the commissioners are all invited.
Because right after that, he invited me to the closed session. Now, there will be one more. There's a fairly short one of one of the GE employees. I then that afternoon heard the GE closed session, and then this is one of the employees the next morning.
Mr. Gregory, you're working at General Electric.
Right.
And would you give us your full name?
My name is Alexander Gregory, 925 Western Avenue, Lynn, Mass., a resident of Lynn for 35 years, and I'm 64 years of age, and I am placed in a position today either to testify as a political informer or lose my job.
Mm-hmm. Good. And where were you born?
I was born in Bulgaria.
When were you naturalized?
Well, it must have been around 1927.
Mm-hmm. Now, you talked about a political informer. We're not interested in your politics. We don't care what your politics are. We are interested in espionage, sabotage, in communism, which has been named by the Supreme Court as a conspiracy against this country, and not as a political party. So we don't care what your politics are.
You say you're interested in sabotage?
We're interested in espionage, we're interested in communism.
Are you interested in sabotage?
Well, let's have a little understanding.
Well, I can help you out in that.
All right, good. That's what you're here for.
I can help you out.
Now, mister, you're going to wait until the question is asked before you interrupt. Do you understand that?
Right.
Right. When did you go to work for General Electric?
I worked for the General Electric Company in 1922 to 1924 or thereabouts.
Yes.
About a couple years. Then I quit my job for various reasons, and I went into business, in various businesses.
When did you work for General Electric last?
And last time I got my job back about 1942, and I have been working there ever since.
You're working there as of today?
What?
You're working in General Electric as of today?
Well, that depends how it comes out.
You were working there yesterday, then?
Yesterday I took a day off. I have to be here.
How about the day before?
Oh, I am very steady worker when I work.
Okay.
Never lose a minute.
You understand that General Electric handles classified work all the way from top secret down to restricted, down to unclassified work?
I have never come in contact with secrets. I work in the lighting division on street lights.
Mm-hmm.
But during the World War, of course, we tested things, equipment that went for the Army.
Yes. Right now, I'm not so much interested, Mr. Gregory, in the work that you yourself are performing. I am interested, however, in the communist meetings which you might have attended, which were also attended by communists who were handling classified work. Now, if you would care to tell us about the meetings that you've attended, meetings of the Communist Party since you went there, give us the names of the communists who attended, which you refused to do yesterday. That would be of considerable help to your adopted country. So you came over and adopted this country as yours.
Right.
Now, you do have information. You do have information which would be of great value to the Justice Department, to the FBI. I asked you for that information yesterday, you refused. I asked you to think that over overnight. I can see no reason why you shouldn't give us that information. You don't seem to be a typical communist. You don't seem to be an evil man.
I don't consider myself evil person, nor does anyone else in Lynn consider me an evil person.
Will you give us that information?
As far as information is concerned about classified information, I don't know no one that has ever spoken to me about classified information.
Mister, we're not accusing you of being an espionage agent. I don't think the party would pick you as one. I want the names, however, of the communists who attended Communist Party meetings with you, communists who are working at General Electric. See, if we get those names, we may be able to find individuals who are more vicious than you are. You may have been a complete dupe. That's maybe why you joined. I'm inclined to think it is from talking to you yesterday. But there's no reason why you refuse to give us the names of those communists.
The thing is, as far as I'm concerned, I have never seen an evil communist.
Mm-hmm.
At least I haven't been fortunate or unfortunate to come in contact with so-called vicious communists.
Mm-hmm.
The persons with whom I have had connection, whether they were communists or otherwise, they have been very gentlemanly and very honest and conscientious and security-minded persons.
Mr. Gregory, you're not the man who can decide whether those communists were nice people or not. You see, Alger Hiss fooled Supreme Court justices to the point that they testified in his favor. So if they could fool Supreme Court justices, they might be able to fool you. We are asking you for the names of the communists, even though you think they were nice communists.
The thing is like this, that I refuse to answer that under the First and the Fifth Amendment on account it would bother my conscience to be uninformed.
Wouldn't it bother your conscience to think that some of these communists are committing espionage and that some of the sons of your adopted country will die because of their espionage? Would that bother your conscience when you go to bed at night?
If anyone that would commit the acts that you claim, whether he is a communist or not, I certainly would give that information right away, quick, to the FBI or any other federal agency.
Well, now, look, mister, I don't assume that they would be dumb enough to let you see them stealing secrets. I don't think they would be dumb enough to tell you that they're espionage agents. The information which you have about members of the Communist Party and yourself would be of tremendous value. Now, you are entitled to refuse to give us the information under the Fifth Amendment. Or, if you want to, you can perform a service for your country today. You have valuable information. We can't drag it from you. If you were in Russia and you had information about Americans who are spying on Russia, you would not sit here and be able to take the Fifth Amendment. You would be in some dark cell and you'd stay there until you gave out your information. And you would give it out. If you try to take a Fifth Amendment there, your life insurance would be awfully high, I can guarantee you. Now, why don't you try to help your country today?
I think that I'm old enough and I'm experienced enough to have the judgment that's necessary to know when a person is really dangerous or of pluck in nature, and when he is not. And therefore, for that reason, I refuse to answer under the First and the Fifth Amendment.
Step down.
It's 4:30, and this is running a little later than usual. We do have cookies and coffee, and I guess we can have some formal question time, but you can stay for a while. If we have any other questions, this can run on for some length of time. So why don't we? Please help yourself to cookies.
Dr. Ramsey, I'm really interested in the problem of the response to the McCarthy style of inquisition, of my term. If, as you illustrated, when the Furry and Cayman cases went to court because they decided they were willing to answer, and also test out the limits, and they won in court with a good judge, wouldn't the odds have improved for lots of other people faced with the things in the public hearings to say, look, I'd like to have a chance to exonerate myself, give me a copy of the text of this hearing? Why was it repeatedly so difficult for more people to, I don't know, gather the courage? I realize the atmosphere was awful, but why was it so late? If it
Well,
before they would go to
first place, I would say the key thing on that was, and that I know full well, was struggling with it. Namely, you might think with the Constitution having been in existence as long as it would, there would have been all sorts of precedents from way in the back. It turns out there weren't good precedents. And in fact, there particularly, as you know, under the Constitution, corporations are treated, and individuals, or corporations are treated as individuals. Most of the precedents that were up for various cases of some of this kind of congressional committees were usually corporations as a body up. And in general, the courts tended to rule, well, it wasn't really individual freedom that was trying. By and large, they were ruling up to that time fairly limitedly on what were the rights of the persons under the First Amendment, because although you could say a corporation was could appeal under the First Amendment, it wasn't quite what the constitutional framers had in mind, and although they granted it was that, it still, the court probably tended to be a little harsher on than if it had been actually an individual that they were confronted with. So the precedents that were available, and I studied these precedents with great care, in the first place were remarkably incomplete. It was really quite unknown. There were two known ground rules. One was that the Fifth Amendment did apply, and the area rule applied, and the second thing was it was tested with a precedent that the a former member, having been a member of the Communist Party, alone was a justification for use of the Fifth Amendment. So that was a solid reason you could do. The only precedents on the use of the First Amendment in this case were actually precedents involving corporations and had been ruled against them. It had been ruled that they couldn't use the First Amendment in the nearest analogous case. They weren't quite analogous cases, it was freedom of speech in a different form, but basically no one, no lawyer, no individual could tell. In fact, the best legal advice was that it was highly unreliable to count on the First Amendment. And in fact, basically that still is not, in that case, is not such a favorable one, because in fact the Furry case was actually the Cayman case was actually settled on the grounds not of the First Amendment, though it was fought partly on that, I'm sure it entered into the consideration, but was primarily settled on the basis of the jurisdiction of the committee.
But I'm as much interested in the question of the different arena for having such inquiries go on. That is, it was long, I thought it was long known that a senator, say, was not obligated to be accountable for his statements in Congress, as they can't be challenged, they don't get cross-examined on the truth of a statement. So I would have thought it would be obvious for a presumed defendant or someone who's been accused to say, I need a hearing in a court of law in order to have a kind of legitimate legal basis.
No, I think on that there's, in the first place, the statement, but to see the thing is, that's one of the confusions. It's presumably a congressional committee investigation, not a prosecution. I mean, they are presumed, the only justice space of just being what they're doing is to find information which presumably is to affect legislation. So that there's no opportunity, the victim cannot demand a trial on it. So I mean, that it's not he that demands it, it's in fact if he's cited for contempt. Now, so the only way you could find, in other words, and this is true basically of all law, unless there is a precedent, the only way you can find out what your rights are is by taking the chance, and then you either make it or you don't. and that particular chance hadn't been taken by individuals, and there wasn't a ruling. It's quite true that as a result of the ruling, say in the Cayman case, this is a very useful precedent. This greatly restricted what the government operations committee could do. It really did provide a precedent, since it was not overruled in any higher court, really saying it had to pertain to government operations. Now I'm sure that if that same committee were now holding a similar investigation, the person being investigated, if he had a good lawyer, wouldn't use the Fifth Amendment unless he wanted to, but would probably, the wise thing to do would fight it on the grounds of the jurisdiction of the committee, and would be automatically settled. But the real problem, I think, the answer to why it went on so long for people doing it is this whole process takes a long time. There was, between the time of the hearing and the time of the court decision, was probably the order of 2 years. And another year before it could have been maybe appealed, so that for a person to have known that this was a legitimate grounds for refusing to answer, he would only have known that 3 years after he'd had to make the decision.
Well, it costs money.
And it costs money. Now, once the decision has been made in that case, of course, then it's easier, because then you do have a precedent to go on. But court, the interpretation of the law and the Constitution is very much dependent upon precedents, and it's surprising after 200 years of existence that there aren't precedents for all kinds of things. But it turned out in this particular area there were lots of precedents for court cases, but the whole congressional hearing procedure really developed mostly in the last 20 years or so, and therefore there really weren't very many precedents, and most of the early cases were always for corporations were up rather than individuals were up. Yes?
Do you recall any efforts within the American Physical Society during this period to raise this issue and to have the society take a stand on the violations of the Constitution, but specifically as they affected members of their own side?
I think as far as the Physical Society is concerned, I think as far as the individual members of it, there was a great deal of thought, discussion. I think no effort at that time made to involve the Physical Society in a particular position. I think the view being probably the dominant view at that time being that was not so much of the direct concern of the society. I mean, there's a question of how much the society should be involved in versus, it was not actually doing very many things of that kind. I don't think it was taking any particular position that I can recall.
Do you agree with that position, and would you agree with it today, that the society should remain aloof?
No, I think this is something that you have to do it a little bit in accordance with what is being done at the time. It is now more involved than previously, and I think correctly should be more involved. I think there is a balance. I think it's probably unwise for the society to get involved vigorously in issues that are fairly extraneous to the society. There are all sorts of things. There are all sorts of ways you can decide what you should and should not get into. I think I think the society was probably running excessively aloof at that time. On the other hand, I do not. There's an opposite extreme to which you can essentially try to have the society take a stand on sort of every issue, and I think that's also a wrong position to do. I think sort of a compromise in between them. You'd have to argue each one out. I think this one probably, from the present point of view, would be argued as enough directly pertaining to the society that it probably would be more apt now to have taken a stand than it would at that time.
Professor Ramsey?
Yes?
Did you ever personally take any abuse for your being on defending Wendell Furry?
I got a large number of abusive letters following also a large number of praiseworthy letters following my Meet the Press hearing. I mean, one of the ones, a lovely one of the abusive, the only one of the abusive ones that I remember was one that had it had this statement, something as our, I think it was, as they got the antecedents and descendants mixed in the letter, as it ended up with an eloquent plea, as our forefather descendants taught us, a man who defends a guilty man is just as guilty as the man whom he's defending, which I consider was, thank heavens, at least not something that our antecedents taught us, and I hope our descendants don't learn that lesson either. For all sorts of grounds. First place, there wasn't that it has an implication of guilt, which was not in it, and certainly defending even a guilty person is not an implication of guilt. In fact, I feel that very strongly. I must admit, I had was quite impressed with, as I mentioned earlier, with the difficulty of getting a lawyer who will take unpopular cases and treat them. Now, it's very easy to get a lawyer who will, if all you do is murder 25 graduate students, there's no difficulty getting a lawyer, or even 25 wives. I mean, there are lots of lawyers who specialize in that. On the other hand, if you have been at that time, if you've been a member of the Communist Party, it's very, very difficult to get a lawyer to defend you. In fact, there's an amusing thing that I did not realize until I've forgotten the name. But the lawyer, when it looked as if the Furry case was going to come to trial, as opposed to the hearing. For the hearing, Jerry Berlin, who I greatly respect for, did a fine job on that, but one of the duties of a good lawyer is to tell you when you need somebody else. And as soon as it looked probable that it was going to come to trial, he is our lawyer on the overall thing, said, now at this point you want to get a trial lawyer, you want to get a good one, and it's hard to get them lined up. You should line up, you should pay a retainer, you got to pay a retainer fee of a few $1,000s, which our department all chipped in for, to get a good lawyer, which we did, and I proceeded to forget the name of the lawyer after that, and got reminded a little later, it was very hard to get one. We finally got one whose belief was, no matter how unpopular the case, I mean, the man deserves a defense, was his view. He'd been one in the law firm with Mr. Welch, who actually later did the Army McCarthy case too, and it turns out it was the same one that Nixon.
Sinclair?
Sinclair, it was Sinclair, whom we hired. I'd forgotten this in Bob Pound. I had some discussion during the Nixon period coming up, and I made some comment and said, don't you remember you helped pay him $1,000? But I found it very revealing as to exactly how he got involved in that case, and I think his later performance really somewhat was consistent with it. I mean, I think he took it was interesting law, and he took it because he felt in that case, from the opposite point of view, the man deserved a good defense. And
but now my question is more socially within your Harvard circles and in Belmont. I mean, just
there was some backlashes, not too serious. Actually, the main ones I was worried about there were pertaining to Furry. I think probably got more. I think I did not around here get much. Clearly. Well, Furry and King, particularly Furry is the more senior one, who the most conspicuous headline is obviously a terrible, well, really about 3 years for him and his family. I mean, essentially to pick up the paper and almost every day find yourself featured on the headlines, almost always in a negative way, is a very unpleasant procedure. And there certainly were many of their friends. I think within certainly within Harvard staff, no, I didn't notice any fraud. I think on the whole there was, I'm sure. Well, there were a large number of people, I think, a large number of people who adopted basically subconsciously a view of McCarthy, which was essentially that, well, it's perfectly all right for him to have been a member of the Communist Party in the past, but it's absolutely terrible to be a Fifth Amendment communist, and to misuse the Fifth Amendment. But and it took a lot of education on people, and a lot of them never did get the education that I mean, the Fifth Amendment's there to be used. I mean, I didn't advocate it in that form. I think it did lead to misunderstanding, but it still is the right of every citizen, and there's nothing improper, immoral about the other. There's a general view it was immoral. In fact, a very strange argument was that if the man hadn't say, been a spy, then it was immoral to use the Fifth Amendment pertaining to a question of that kind, because he could have answered the question truthfully otherwise, and you weren't therefore incriminating yourself, of course, with the area rule for one, that you had to do it, and secondly, it's a perfectly, I think there's a, very fortunately in our law, this is not true in all countries, but in our law, I think very wisely, there is the moral grounds of the decision and the legality of the decision are quite clearly separated, i.e. if you are driving 55 miles an hour just under speed limit but you really would have loved to have gone 85 miles an hour, but your old clunker of an automobile can't go faster than 55 miles an hour. A policeman's not entitled to arrest you and say, but the only reason you're going 55 miles an hour is that you can't go any faster than that. And the same is true on the Fifth Amendment. If you're entitled to use the Fifth Amendment, you're entitled to use the Fifth Amendment. And if the reason that you want to do it is that you can't bring yourself to tame the names of the people, that's morally perfectly all right. It's not dishonest to use it in that case. Now, it has this objection that I mentioned earlier that these committees fed upon that. But it's certainly not immoral to use it. You do that all the time and should.
Right. Just a comment. I mean, it's always incredible to me when people use the kind of rationale that McCarthy was using in your tape, where he said, how can you use the Fifth Amendment when in this country you should be lucky to be using the Fifth Amendment?
Yeah,
well, on that rationale, right.
Well, then we give it up. That's exactly right. I mean, you're precisely right. That's a good illustration of it. I mean, it's sort of the process of getting rid of it while boasting about it.
Exactly.
Yes?
In some recent congressional hearings, witnesses have avoided similar dilemmas by saying that they don't recall, presumably under the advice of a rather famous lawyer. I wonder whether anyone...
Well, the don't recall one is a very tricky one. If you really don't recall, that's great. On the other hand, and it is true, it's a little hard, it's really a hard thing to prove. But strictly speaking, saying you don't recall when you do recall is perjury, if it's a sworn testimony. Now, some people seem to have convenient, McCarthy being one, who has convenient, forgettable memories. On the other hand, most scientists can't forget quite that easily. And I think I would certainly not recommend, I would not recommend anybody committing perjury, which it is committing, and using that particular out. Because it's true, you may get away with it. I think you have a reasonable chance of getting away with it, and certainly in some of the recent Watergate-ish incidents, people seem to be rather plagued with rather phenomenally bad memories. And I think, as I say, I think you can probably get away without working too hard to jog your memory. But I think you basically have a real risk of getting into serious trouble, as many of those did.
But this possible tack didn't come up as an alternative.
Oh yes, that certainly was thought of as an alternative, but also was also recognized as perjury and strongly advised against. And actually, in the case of somebody like Furry, he is intrinsically and extremely, I think he suffered from being too honest. He never would have, I think he would never have dreamed of doing that, never, even if it had been advised by lawyers, but it was not. I mean, in fact, they were quite strong, I think correctly strongly advising against it. The real problem is it's really taking a tact on a kind of a hearing like that, as the Watergate people mostly found out. They tried to take a tact which involves perjury, is very, very hard to maintain because, when you get an unexpected question here and the two stories aren't quite consistent, and even if the perjury is only involved in the limit of not remembering, then, it suddenly turns out, well, you pick one case that you even could justify saying you don't remember. Then they ask you another question which is a little closer, and then they finally come out with a witness that heard you talking about that case at the local bar 3 days ago, and you sort of you've had it at this point. So that I think it's, I would strongly, of the possibility, I think you should use first place, there shouldn't be such a procedure. I think really, it's a very real problem, which I think needs to be worried about and isn't worried about enough, are two different things, one of which I also had some experience with since I was involved as a witness on it. Both government security hearings and congressional committee hearings have very real problems as to being possibilities of being very unfair to the subpoenaed witness, because in many respects the penalty is the hearing itself, particularly if it's a TV program. The penalty, although it's not officially a trial, actually I think Furry would have been, let us say, far better off personally and his family if it had been a nice quiet trial, no TV, and spent a couple of months in the clink. That would have been, relatively, nobody would have known it much. But on the other hand, this is conspicuous in the papers for a while. The punishment is the hearing itself. Since that is a very severe punishment, there should be fairly major efforts taken to try to accord some of the justices and protections which do go with court hearings and trials.
Did the area rule get changed from any?
No, the area rule still, that ruling still maintained. It gets slightly modified as further hearings go. It's been narrowed, I believe, since that time a bit more. I'm not sure that all of communism is now treated as a single area, but since I fortunately haven't been involved in one of these cases recently, I've not studied all the precedents the last few years, but my guess would be that out of the array of cases that came up in that period, that there probably now is a more precise definition. I could well imagine, for example, I think that a very wise move on the part of the court to, let us say, split communism into two categories. One would be the sort of the non-illegal, essentially basic activities, or not much more than membership of the Communist Party, and secondly, into those which involved espionage, and say that those are two different areas. If that were done, that would have pulled the rug out from under many of the committee's activities.
Well, is this how they tracked the Hollywood 10? Essentially the same thing.
Very much the same. Hollywood 10 was very much the same thing, with their being, their public, of course, being ones that didn't know. Most people don't know the subtleties of this. No, Hollywood 10 I understand full well. They're probably just the same kind of people exactly as the scientists who were involved later. But of course, with their employment groups, namely the movie industry being one feeling very dependent upon their public image, and not very desirous of standing very firm. So most of them were in very deep trouble. Yes?
Was there no class action suit raised by those 11 or 12 people who were fined by GE? Because it's illegal. Like you cannot make a contract which signs away a person's rights guaranteed by the Constitution. Like a dentist can't sign a contract saying you will not sue him for malpractice.
I would think, personally, I would think that there would have been a very good opportunity for that. At that time, with the unpopularity of it, I would have suspected it wasn't thought of. But I would think, under present circumstances, yes, that would be quite feasible. I'm not sure the class action suits were also so common then, but no, I agree with you fully. I think that would be a very effective way. I don't know of any such issue being raised. I must admit, I had a certain little bit of sadistic pleasure about 4 or 5 years later when GE and Westinghouse and all the big power equipment manufacturing companies happened to be brought up on an antitrust and price fixing suit, and lo and behold, what happens? GE as a corporation exercises the Fifth Amendment. Having said they're going to fire people, and so did the president, and so did the vice president, in fact almost all the officials. And I was sorely tempted to write in and say, what about this policy?
In Gulf Oil, that just happened. They just got rid of the top echelon of the company for that with the bribery case.
Not for claiming the Fifth Amendment.
No, but I mean...
Yeah, with the bribery. That's right. I have a feeling they probably got rid of some of the top echelon of GE on that same basis, but not, as far as I know, on the basis of their use of the Fifth Amendment, which they did use. Now, they used it in the conventional form, which people understand. They used it by not allowing the government to examine their books of the company, and they used it by many of them not appearing as witnesses. But that everyone is used to. When the same thing is done before such committees over TV, and when McCarthy, let us say, says, well, this is sure demonstration of guilt when the man refuses to testify on the grounds, as he would put it, that his answer would incriminate him, why, obviously it's interpreted as equivalent to guilty. Yes?
On that note again, well, not particular. When was it thought that you could first use the Fifth Amendment for these hearings? Because since you're not being prosecuted, you can't incriminate.
That was somewhere there's a very clear case. It's not whether you're prosecuted on that case. If the statement you made there could be used later against you. And in particular, there was this, rather fortunately possibly for members of the Communist Party who came up on this, there was a thing known as the Smith Act, I think that was its name, which had been passed, which at one stage, somewhere in the early 40s, had declared it illegal to be a member of the Communist Party. So then a Supreme Court case had already come up, which said in view of that case, membership in the Communist Party, past membership in the Communist Party, combined with the Smith Act in itself, justified you for using the Fifth Amendment. So there was clear justification. Now, your moral reasons for doing it in most of the cases wasn't that, but was in fact that that was a legal means of avoiding the necessity of naming people's names. I think that was true in almost all of the cases, was the reason they did it. But it, of course, had the bad associated problem, then you had to refuse questions in other related areas.
Let's stop the formal questions now. Informally, Professor Ramsey is happy to stay a little longer, but let's thank our speaker for.
Yeah, what we didn't, if we had, I didn't think about putting if that doesn't come through, we could play it again for him.
Okay, maybe I'll ask you about that later on, although I did check with you before and said it was loud enough to hear.
Could you hear? You can hear fine. You can hear in the back. Good, fine. I was a little worried about it. It isn't that high quality recording.
It was done live.
Yeah, sure. Sure, fine. Glad.
Norman, did the Meet the Press? Did they tape it at the time?
Yeah, well, I have the soundtrack of it. I have the soundtrack.
But they didn't. But the video.
They videotaped it. Yeah, they didn't have videotape at that time. But I do have. They gave. Yeah, but they.